Company of Trinidad and Tobago.
Mr. Clayton, good morning.
Good morning, my lords and lady. In this matter, I appear together with Mr. Ram Logan, Mr. Chris Knight, and Chelsea Stewart. And my learned friend is rather outnumbered, but I think has had some assistance from Trinidad, Mr. Rose. My lords...
But not Ms. Martineau.
Not Mo, I think she's from Trinidad and has
Very well.
declined to join us. The position is, very briefly, as my lords will know, that Petrotrin, the respondent, is a state-owned petroleum company of Trinidad and Tobago, and effectively, in the light of the printed cases, this appeal has crystallized really into one issue only, which is in relation to the public interest override, Section 35 of the Trinidad Act. And for the purposes of oral submissions, I propose to focus on Limb 2 of the override principle, and our submission to my lords and lady is that there is a realistic prospect of success, focusing on the second limb, that in the circumstances giving access to the document is justified in the public interest, having regard both to any benefit and to any damage that may arise from doing so. In our respectful submission, I say there are two limbs to Section 35. That's the conventional view. Indeed, it's obvious if you construe the section. And in our submission, that second limb imposes two requirements: that access is justified in the public interest, where I'll show you in due course that the onus is on the public authority to effectively show that's not the case. And then, rather importantly in the context of this case, a mandatory requirement to balance the benefit of disclosure against the damage which may arise. It's the balancing exercise. And what is striking in this case, to crystallize the submission even more, is throughout there's been no balancing exercise undertaken at all, and I'll demonstrate that in due course. So,
sorry, can I just ask, what do you say is the test for the court in assessing whether these two requirements have been satisfied? Do we look at the rationality of the decision of Petrotrin, or is it an objective test to the court? It's
an objective test. I should say, urge a little bit of caution at this stage. There's a lot of Trinidad jurisprudence on this, and if one looks at the jurisprudence from there, the principles are really very settled, and I will take you to that.
Right. So what's the answer to my Lord's question?
The answer to my Lord's question is that both in the response to the FIO request and for the court, they have to demonstrate that they have gone through the balancing exercise. They have to identify both the benefits and the damage, and effectively what's happened here is the court has passed over any consideration of the benefits of disclosure.
But when the court comes to consider what Petrotrin has done, are they making their own decision on the balance, or are they looking at the justifiability of the decision, which Petrotrin...
Making its own decision. It's not a Wednesbury irrationality question. If I may say so, and I don't want to stray too far, because I do want to look at two or three cases quite carefully. There's particularly a court of appeal, an important court of appeal authority, which deals expressly with Section 35. I should also say, which is also important, it sets Section 35 in its constitutional context, particularly Justice of Appeal Jamadar. And there is really quite a lot of established principles to be applied. And the other point to make is that the principles to be applied are wholly different, really, from the freedom of information regime in the United Kingdom. So,
Is the only method of appeal from a decision by a public authority under the Freedom of Information Act via judicial review?
Yes, I'll take you to the statute shortly.
Yes. Well,
yes, the answer to that is yes.
Yes. Well, in that case, I want to see on what legal basis this court it can substitute its own decision for that of a public authority.
I can't help feeling, if I may say so, that once I take you to the cases, I will be able to elucidate that better than doing
Mr. Clayton, we'll let you get on with it.
Thank you. My Lord and Lady, As I've briefly said, the Freedom of Information Act in Trinidad confers a different and stronger right of access to information than in the United Kingdom. I want to emphasize that this application for leave for judicial review arises out of an application to seek access to witness statements in an witness statements given to a London Court of International Arbitration award made on the 22nd of April of 2014, which is said to justify an opinion by counsel, Vincent Nelson QC, that the High Court proceedings brought against the executive chairman, Mr. Ernest Young, who is alleged to have dominated the board and failed to comply with various duties in entering into a joint venture to construct a gas-to-liquid plant. And the first point, I'm going to develop these, but one thing which is really very obviously striking is the arbitration proceedings were about something completely different from and I'll take you to a brief summary of what those issues are, but they're about something completely different from the criticisms of Mr. Jones, which was the High Court proceedings. And with the greatest of respect, and I'll take you to Mr. Nelson's opinion in due course, which is, if I may say so, rather weak. But it's really difficult to understand how issues which have nothing to do with one set of proceedings are said to justify, or witness statements connected to one set of proceedings with different issues is said to justify the withdrawal of a claim which is completely different. It really is as simple as that. So what our fundamental point, my lords, is this, is as I will seek to demonstrate in our submission, the second opinion of Mr. Nelson, which is the one which is said to justify the withdrawal of the proceedings based on the witness statements given in the 2014 arbitration, is with respect very obviously very unsatisfactory. And there is widespread public concern that the Trinidad government has written off very substantial public funds without proper justification. And to give you some context to that, again, I'll explain it. I'll get Mr. Ram-Logan to go through the facts in a bit more detail. The claim itself against Mr. Jones was for $97 million US, and the losses sustained by this exercise was told by Petrofin executives to the Parliamentary Select Committee was $3 billion American dollars. So if I may say so, it's hardly surprising that people want to get to the bottom of what on earth went on, and I won't overstate the position, but when we turn to the second opinion from Mr. Nelson, it's a striking document, and I'll indicate precisely why I say that.
Could I just say, I was slightly mystified when you said that the witness statements for the arbitration tribunal were about something completely different from the criticisms of Mr. Jones.
Yes.
I'd rather got it into my head, but this may well be wrong, that the whole exercise of investing in the plant was the subject of the arbitration proceedings, with Petrotrin saying, for various reasons, they had a claim against World GTL.
Well, the answer is...
And sorry, I'll explain, and then you can tell me why I'm wrong. And that the proceedings against Mr. Jones were on the basis that he had been instrumental in some way in causing Petrotrin to enter into this loss-making transaction.
My Lord's last 2 points are correct. The fundamental point, however, and I'll take you to the opening 10 paragraphs of the arbitral award, which explains the issues that particular arbitration considered. The one thing that arbitration was not about was Mr. Jones's stewardship or role in the company. It really wasn't about that at all. I mean, it may be that you'll want to read more than the first 10 paragraphs, but I'm trying to go through this as quickly as I can, but the short point really is that the defalcations of Mr. Jones was not at the center of the arbitral award. It really wasn't, and you can see that. It's very obvious from the summary of the first 10 paragraphs of the arbitral award, which I will take you to.
Well, it's fairly obvious that the litigation against the other company wouldn't be focused on alleged failings of someone within Petrotrin.
My Lord, yes, and that's precisely our point, if I may say so. That is precisely our point, and that's what's so unsatisfactory about the way in which this case unfolded. But can I just pause there to let Mr. Ram-Logan will take you briefly through the public interest and the factual scenario to this, which is certainly caused, because of the figures I've already adverted to, considerable concern in Trinidad, because Trinidad was no longer a major employer and was a very large company, or remains a very large company in Trinidad.
Mr. Clayton, the board knows Mr. Ramlogan very well and has the greatest respect for him. Can you, before he gets to his feet, just explain whether, as caught my eye reading this carefully yesterday, he has had a role in this?
Yes.
Was he the Attorney General for Trinidad and Tobago prior to the general election of September 15?
He was.
Was he then the Attorney General right up until the general election?
No, he
Or
wasn't.
had he passed it on to somebody else?
That's correct.
When did he do that?
Can you remind me? January 2014 was when Mr. Ramlogan stepped down as Attorney General.
Was he then party to the decision to sue Mr. Jones?
I think, well, party puts it too high. He was the person as Attorney General who instructed both, it's in fact two people, because it was Vincent Nelson, Queen's Counsel, and then also Mr. Russell Martineau, who's a very well-known senior counsel, on the basis of both those advices, which are in the papers.
Has consideration been given to whether, in the light of Mr. Ramlogan's political role prior to January 2014, it is appropriate for him to be counsel for your client today?
As I understand it, yes. As I understand, yes, it has been. And there's no particular personal element to this, although I am going to take you to the Attorney General's press statement in 2016, I think, which makes reference to Mr. Ramlogan. But as my lawyers will know from Trinidad cases, the political vocabulary is often rather colourful. But he had no role directly in this. He instructed counsel. He, in 2012, gave a press statement which referred to the first set of arbitral proceedings, which we know very little about, and I'll come back to that in due course. But he had no direct role. He was the Attorney General. I mean, that's...
Who took the decision to sue Mr. Jones?
Well, as I understand it, the government did on advice from counsel. And the advice is there, and the advice is clear.
Yes, I've received that.
I mean, I don't think...
But I mean, advice is one thing. Advice is given to a client who then takes the decision what to do in the light of that advice.
As I understand it, I'll just check, but I'm certain it was the cabinet. Sorry.
That's a very good point. I'm slightly concerned.
Yeah, well, two things. First of all, as this maybe not be a surprise, it was the cabinet who decided. It wasn't obviously, well, perhaps not obviously, but it wasn't the Attorney General. And the Board of Petroleum, I'm told as well. Sorry,
Yes.
And in
I mean, I think some of us have some lingering discomfort about this.
Well, may I deal with it this way? I think Mr. Ramlogan has heard that, and I'm happy just to carry on, because I have some submissions on the facts.
Your plan, you've got to put Mr. Maharaj's case to optimum. And if your plan was to have him explain certain things, we don't want to interfere with that.
Well, I think...
But from our perspective, there is an element of discomfort about it, Mr. Clayton.
I understand the unease, and I'm in fact perfectly able to take my lord through the whole case, so my lords and lady. So may I, in those circumstances, just bat on alone, despite having...
Are you happy then? Yes. Bat on, please, Mr. Clayton.
Thank you very much. Seldom get such an enthusiastic opportunity to. The position is this, that as I began by saying, there is, and this is quite important, an established body of appellate jurisprudence in Trinidad about the interpretation of its legislation. And what I want to do is take you to legislation first of all, and then which you'll find in tab 1, which is on the electronic bundle, is page 1126. My lords and lady have that?
Yes.
I want to begin with section 3, which is a very important section for the proper interpretation of the Act, and also has no analogy with the UK legislation. It really defines the object of the Act. It says the object of this Act is to extend the right of members of the public to access to information in the possession of public authorities, A, by making available to the public information about the operations of public authorities, etc. B, creating a general right of access to information limited only by exceptions and exemptions necessary for the protection of essential public interests. Can I draw attention to the word necessary and essential, because that very precise limitation section 3B imposes attract some discussion by the Trinidad Court of Appeal. And then, if I may invite you to turn the page, subsection 2 says the provisions of this Act shall be interpreted so as to further the object set out in subsection 1, and any discretion conferred by this Act shall be exercised so far as possible so as to facilitate and promote promptly and at the lowest reasonable cost the disclosure of information. So that's the object clause, so to speak, unusually.
And can you help us with the relationship between A and B? Because, I mean, the information in this case seems potentially to fall within both.
Well, yes, it does tend to fall within both.
What I had in mind, but I welcome your assistance, is whether A is, if you like, a more pointed or stronger interest that in a democratic society, information about the way public authorities conduct themselves is an important interest, something going beyond just generally having access to information in the possession of public authorities.
I'm not sure, looking at the approach the Trinidad courts take, I'm not sure that's the distinction they draw between A and B. I think that B is seen as facilitative of A rather than being a sort of a kind of different.
Right, so they have there's no sort of structured relationship between the two, is it?
No, I don't think there is. I don't, not in terms of classification, I don't think.
Yes, and so you would say the exemptions that are referred to in B apply also in A?
Yes, that appears to be the approach.
That's
yes.
the approach taken. Yeah,
that appears to be the approach. And I don't think there's any issue here about documents, but just to remind you, if you could turn through to electronic bundle 1128, there's a definition of public authorities. And if you turn through the next page, it's I, little I, a company incorporated under the laws of the Republic of Trinidad and Tobago, which is owned or controlled by the state. That's the territory we're in.
And I don't think that's contested.
No, I just thought that I should
thank you.
Draw attention to it. The next section I want to take you to is 1138, please. Section 11, do you have that?
Yes, we do.
Notwithstanding any law to the contrary and subject to the provisions of this Act, it shall be the right of every person to obtain access to an official document, 11.1. Now that's quite important because that means that the Act prevails over any other legal obligation. I shall also be making a submission in due course anyways, that Article 30, which is the relevant article in the arbitral arrangement, itself doesn't prohibit the disclosure of information. So the whole approach taken by the Trinidad court is simply difficult to understand. It doesn't even get off the ground, the suggestion that this stuff is somehow confidential. in a strict sense. Now, because of the concession made in the Court of Appeal, I don't think I will show you, but I don't spend any time looking at Section 32, which is the obligations which relate to material obtained in confidence. Sorry, that's at 1156. I am so sorry. And
Yes.
that's the territory we're in, but we concede that that applies. And then can I take you to...
Can we just look at Section 32 a little more? I know you
Sure.
can see that it applies. It's talking about disclosure of a document which would divulge any information communicated in confidence by or on behalf of a person or a government to a public authority. So it's talking about communications by or on behalf of a person to Petrotrin. That's the public authority.
That's correct. And
So
in
the
this
argument is that these two witness statements by directors of Petrotrin are communications by them to Petrotrin. And my
Yes.
question for you is, Petrotrin can only speak by its directors. Why were their communications not communications by Petrotrin rather than to Petrotrin?
Well, I think there are two answers, actually. Mr. Ramlogan reminds me they're not directors, they're employees, the actual witnesses who gave evidence.
Okay, if you think that matters.
Well, it may, I'm just strictly speaking, that's the difference. And the other is that, as I understand the case that is made by Petrotrin, it is that that because it's given to an arbitrator, that makes the witness statements confidential. That is, I mean, I'm going to take you to the FOI material, the FOI request and their answer in due course.
No, we're not talking about to the arbitrators. We're talking about communications to a public authority. And you've just shown us that the relevant public authority is Petrotrin.
Well, that's true.
And I mean, they presumably were supplied to Petrotrin before ever they were supplied to the arbitrators. So
That's also true. I mean, I can't help feeling that I may not be the best person to explain this point, but I accept the force
I know
of
we've
my
gone through this threshold, and we're into Section 35, but you can't blame us for looking at that and querying it in our minds. And equally, if you've got subsection 2 around,
Yes,
Mr. Clayton, you can't blame us for reading subsection 2. This section doesn't apply to information that relates to other matters of a business, commercial, or financial nature. You can't blame us for putting a question mark. Why does Section 32 apply at all?
Well, may I say, two things at least. First, I don't blame anyone. Secondly, it is very odd, but I'm handicapped by what happened in the Court of Appeal. And I've not, in the Court of Appeal, there's a reference to the transcript, and it seems as if it may not. Let me put it this way. It's not entirely satisfactory seeing how this falls within Section 32, but I accept that. And it may be that...
Forgive me, don't we need to grapple to some degree with Section 32, because that's going to be the public interest that weighs against disclosure. So the more you're into the heart of the interest protected by Section 32, one might think the more there has to be countervailing public interest reasons to outweigh that. But the less you're in the heartland of Section 32, maybe the less is required to show that the overall Section 35 balance comes down in your favour.
Well, that, with respect, that I would respectfully agree that must be right. I mean, I think...
So can you assist us then?
Well,
with
let me try and assist you as best I can. As my Lord Wilson rightly says, subsection 2 doesn't appear to be in play at all. So, as far as we can see, we're here dealing with what's said to be subsection 1b, exempt documents because it divulges information communicated in confidence by a person. Well, presumably what would have happened is both the draft and final forms of the witness statement to the arbitration would have been communicated to Petrotrin. That's presumably, I mean, I can't help you because We haven't seen any evidence from Petrotrin at
But
all.
it's Petrotrin's evidence.
Yeah, it is Petrotrin's evidence. I agree.
So they must have had it before they gave it to the arbitrator.
No, I understand that. I mean, I don't think, if I may put it this way, I don't think the Trinidad courts approached this question in a particularly rigorous way. I mean, basically, okay, maybe it's helpful just to see what's said.
I don't think you can blame the Trinidad courts. I think it's just some of us provisionally wonder. We haven't heard from Mr. Rowe.
Yeah.
Some of us provisionally wonder why we're, passing over Section 32 and into Section 35.
Well,
the reasons that Lord Sales has explained.
Yes, and let me put it this way. I would have developed some fuller submissions about the applications of Section 32, but for the concession which Mr. Rowe points out. So if I can sort of take a slightly agnostic position, I accept the concession was made. Whether it was rightly made is perhaps a different point. And with respect, I perhaps should have thought about it more than I have done. But there are, with respect to Mr. Rowe, some real question marks about how Section 32 does apply to the witness statements in question.
Well, he may answer them. We've gone beyond it. We can't spend too long on it.
No, I understand that.
But he must be entitled to, and knowing him, he may well produce some really, impressive answers. But you've got to proceed.
Yes.
You've got limited time.
Yes.
You want us to go to Section 35.
Yes, if I
Very well.
And Section 35 is 1158. And can I just invite you to read it, first of all?
We've read it.
Oh, you've read it, okay.
We've read it in preparation.
Thank you.
And we've skimmed it now.
Okay. So I just want to make two separate points, really, about Section 35 at this point. The first is that Section 35 is conventionally regarded as having two limbs to it. The first, which involves the reasonable evidence of four separate limbs, has or is likely to have occurred. That's limb A, let's call it limb 1. And then limb 2, in the circumstances giving access to the document is justified in the public interest. Now, I do not propose to go beyond our written submissions in relation to the first limb. So far as we have a case on the first limb is concerned, it's set out in paragraph 66 of the case, and I'm going to leave it at that. I'm going to focus most of my attention on the second limb. And the next and last section I wanted to take you to is Section 39, which you'll find at 1161, which confirms that a person aggrieved by a decision of the public authority may apply to the High Court for judicial review. So that's the remedy. Now, what I next want to do is there really is quite a developed jurisprudence in Trinidad about how this legislation is to be addressed. And in fact, as it happens, Mr. Ram-Logan has been in many of these cases. And what I want to take you to is a very recent case which sets out the established principles so that it helps us. And that is a case which we'll find at 1760. It's or tab 16. It's Maharaj and the Port Authority. If you just let me get that. And you'll immediately see after I go through this why this is really so different from the UK.
And this isn't under appeal so far as you know?
As far as we know, no.
Very well.
It's not under appeal, I'm told. And you'll see that Mr. Ram-Logan was acting for the claimant. And the reason I'm going to take you, I'll just explain something briefly about the case.
I'm so sorry, I missed the page reference.
Could you turn the case begins at 1759, but I want to go to 1760, just to set the background to this. It's basically about a procurement complaint.
And this is, the claimant is not your client, It's a different Mr. Maharaj.
No, that's right.
Yes, very
It's
well.
in fact actually, I think the Maharaj who I had the pleasure of representing before my lords in October.
Very well.
Not my Lord Hodge, I should say. Picking it up at paragraph 6, basically what this was about, and I just invite you to read paragraph 6 regularly, not all the stuff that follows, is this was a complaint about ferry services.
About ferry services?
Yeah, about the lack of unreliable ferry services and complaints of mismanagement, inefficiency, incompetence, lack of transparency in a procurement process for it. That's the thrust of what the case was about. And then what I really want to take you to is 1171, which is a very helpful summary. This is a very recent case. It's in January.
1171.
1771.
1771, sorry.
Very well.
And this is a very recent case, January, and it sets out the relevant principles quickly. Taking it from paragraph 27, the defendant does not dispute the general principles applicable to a decision not to disclose documents pursuant to a request, and they can be summarized as follows. 1, the court, in interpreting and implying the provisions of the Act, is mandated to do so purposively so as to further the policy, purpose, and objectives of the Act. And that's an important principle which is developed at some length in the leading case on Section 35. 2, there is a presumption in favor of disclosure as the Act is considered a revolutionary act designed to open up the workings of government and administration to scrutiny for the benefit of every citizen, representing a paradigm shift in public information. So paradigm shift, radical, these are obviously striking words. 3, the general right to disclosure is limited only by exceptions and exemptions necessary for the protection of essential public interests. And again, the cases, as you will appreciate, emphasize the word necessary and essential, which I asked you to underline before. If I could ask you to turn the page to 1773, 4 and 5 aren't relevant, but 6 is very interesting. 6 says that the court is permitted to inspect documents for which an exemption is claimed in order to permit it to make its own finding. And that's why Mr. Ramlogan asked in the letter following the request whether they might come in a redacted form, because it is conventional in Trinidad for the court itself to express its own view about the exemption.
But you wouldn't do that in a redacted form. That looks as though the court just looks at the document, not necessarily the other side being allowed to look.
I agree, but having got redacted form, then I think the submission is made in due course that the court should take a look, because the court...
I didn't understand that Justice Devine was invited to inspect the document.
No, he wasn't, because
Very well.
we hadn't got as far as that. Well, what had happened was this, that there's a letter before, the pre-action protocol letter, it's rejected, and then a second letter from those acting for Mr. Maharaj, who say, well, can we see it in redacted form? And that too is rejected.
Yes.
That's the only point I'm making. Then 7, there is no need for the applicant to demonstrate why the document or information is requested, save where a question of public interest arises, and the applicant is able to demonstrate that his personal involvement may cause an element of public interest. Then 8, Section 35 creates an override that allows the disclosure of otherwise exempt information. 9, recent case law now establishes that it is generally for the public authority to establish there is no overriding Section 35 interest, which would allow access to an exempt document. And that's important because where it poses the onus, so the burden of proof. It's on the public authority. 10, sorry, I'm now on 1774, where the public authority has claimed exemptions, they are required to conduct the Section 35 analysis, and where it has not been done, the court can revert the matter to them. Well, they have here, or purport to. 11, The term public interest embraces a wide range of considerations, including the citizen's right of access to information in a constitutional democracy, fair treatment of citizens, and the need for justice to be done, particularly in cases concerning the promotion or disbursement of government funds.
Sorry, just on 10.
Yeah.
That somewhat makes it look as though the relevant decision is that of the public authority,
Yes.
not the courts, which might indicate that the test actually is a rationality test.
Well, I'm going to take you to authority which says the very opposite. So,
All right, okay. So we wait for that.
please, yeah, I'm doing this as quickly as I can. I won't be too long, I hope. The justification for this public interest evaluation and override, even where documents are considered as exempt, has both specific and general statutory underpinnings as well as a constitutional warrant. And as such, there is a legitimate need for disclosure intended to uphold constitutional provisions. Disclosure would be encouraged. Now, that's really, really important. I mean, the overwhelming thrust of the Trinidad jurisprudence is disclosure has to be made, unless there are compelling factual reasons to the contrary. And I'll remind you now, although you'll know this, that of course the respondent has yet to put any facts in play, and that makes a decision to refuse leave striking.
But you're not asking, I didn't think you were asking for disclosure intended to uphold constitutional provisions.
No, it's not about, sorry, I misexpressed myself. The point is that the obligation to disclose has constitutional underpinnings, important constitutional, which are discussed at considerable length in the case I'll take you to shortly.
You say the respondent hasn't put in evidence. There was no room for the respondent to put in evidence at the stage when this was decided.
Well, that's true, but the judge, in I'm sure a slip of the tongue,
I know, that's a different point.
Yeah, no, I accept that, but all I'm saying is that given the fact that the Section 35 works if you have specific factual material that justifies setting to one side the general principle, we haven't got to that point, that's all. So it was premature to draw up stumps. That's all I'm saying.
Okay. Yes?
Right, sorry. My learned friend, Mr. Knight, has drawn me to... Can I just... I took you to... I think, had I got to 13? No.
You were just coming to it.
You've just done 12.
Thank you very much. The public interest in in favour of release has to be balanced against the public interest in protecting the release of information. We're going to look at this in more detail. It's Justice Afil Jamadar, who says this: when one comes to the evaluative exercise demanded by Section 35, insofar as the denial of the access to information is justified, both a public authority initially and a court of review subsequently are obliged to carry out the required balancing exercise in the context of the above stated statutory and constitutional framework and values. It is critical to note that the carrying out of this evaluative exercise is for the public authority to demonstrate that the denial of access is justified because it is necessary for the protection of the essential public interest. As already explained, essential qualifies both the types of public interest and the degree of circumstance in which the justified denial overrides the mandate. Now, pausing there, I will take you to a further passage. I think it's from Barreau rather than from Jamadar, which specifically says it's not a rationality exercise. Well, sorry, I'm being reminded that. Well, I think what I'm being reminded of, if you look at paragraph 40, that's clear from the words itself, that they are...
Paragraph 40?
Yeah, the paragraph 40 is quoted in 13,
Oh, I see.
which I just read from,
Right, yeah.
are obliged to carry out the required balancing exercise. That's the point that's been made to me.
Well, if Barreau J.A. has said it's not irrationality, I think we would like to see that.
Sure. Well, I'll come to that
Very well.
fairly shortly.
Yes.
The last bit of that I wanted to take you to, and actually, in a sense, this makes good the kind of point that my my Lord Sales has raised with me, is the level of scrutiny which is given to a statement that material should not be disclosed. If I could invite you to turn through to 1179, please.
You mean 17?
Oh, I'm so sorry, 177. I'm sorry. I seem to have numerous these problems.
Yes.
If you could look at paragraph 38, what essentially the court is saying, if I could just make the submission first, is who on earth is this witness who says that it shouldn't be disclosed? And they make a number of criticisms of whether they're an appropriate person. Can I ask you to read that?
I'm so sorry, which paragraph?
It's 1779, paragraph 38.
Yes, we'll read it. Yes, so this is a dissection of the identity of the individual refuser.
It is, and you'll note, this is at the top of the 1780, that the court has no evidence of their expertise or ability to speak on the matters which relate to the reading or interpretation of the bid or tender document. So this isn't a rationality test of saying, well, is the person...
Well, it might be said that's just it is. It's just that they put up the wrong witness who doesn't have the expertise to go into it.
I will demonstrate. I'm sure in due course I can satisfy my lord. But if I may provisionally take the position that it's an issue of law. Now, the next bit I want you to look at, please, is paragraph 40 onwards, really to make good this proposition that. You'll see that the evidence is itself robustly scrutinized. This is not a light touch rationality exercise.
You want us to read 40?
Yes, please.
I mean, it's fairly long and you've got limited time. We'll do it if you want us to.
Oh, well, okay. Well, I mean, I can pick it up from the middle of 1781.
Very well. Conclusion
reached was not grounded in the factual matrix. Essentially, it wasn't properly grounded. And if I can take you to 1782, yeah. From this analysis, it's clear that the court was not given any factual information to allow it to come to its own conclusion. I draw attention to its own conclusion, but rather the information she gave amounted to the imposition of her own unsubstantiated conclusions. Well, with respect, that is no way near a Wednesbury conclusion. 42, respectfully, this is not the way such an exercise has to be conducted by this court. As the authorities have cited over and over, the burden is on the defendant to establish the factual basis for the exemptions, and that establishment calls for cogent and reliable evidence of facts, not conclusions. Therefore, without more, this court cannot come to the conclusion that the report is exempt for any of the reasons given. So it's, if I may say so, a very robust rejection of the respondent's case. So I hope that would be helpful in terms of setting out the overarching principles in a very helpful and current way. And now I want to turn to, if I may, some other cases which are of assistance. The first one is...
Just before you do that, cogent and credible evidence. So the court is looking for witness statements, affidavits, specifically to support. And without that, the implication is that that disclosure will be ordered. Is that your submission? Yeah.
Precisely so.
Thank you.
And because it's kind of hit the buffers rather early on, they just haven't got to the stage of ever looking at any evidence. So that's why it's, amongst other reasons, why it's wrong in law to reach the conclusion.
Well, I mean, very strictly, 42 is looking at whether it's been established that the material qualifies as exempt material, and you can see that it is.
Well, with respect, my lord, that the language says that, yes. But if you look at the analysis which predates it, what he actually means by it is the whole exercise. When he's talking about exempt, it's exempt not simply for the purposes of establishing its exempt document, but whether it's exempt by virtue of Section 35. That's a submission.
All right.
In our submission, the conclusion deals with both the exemption and the justification. Now, I just want to come to, forgive me, the case called Caribbean Information, which starts at 1315, but if you could turn, please, to 1319. Sorry, actually, that's wrong. Sorry, could you, forgive me, could you please turn to 1316?
Yes, of course we can.
This essentially, as you'll pick this up from paragraphs 1 and 2, is about the refusal to disclose certain documents relating to police investigations into a death. That's the first two sentences of Justice of Appeal Ramadar's judgment. The refusal was principally on the basis of exempt and an inability to consider disclosure. And what's significant in this case, and it is a case which I'd invite you to look at more leisure, what's significant is that the judge takes the view that he reverses it because the final order, this is paragraph 3, he disagrees with the final orders he made. In my opinion, the trial judge failed to properly consider the intention and purpose of Section 35 of the Act and the practical implications for the respondent in the context of the scheme. In my opinion, the respondent had a duty to consider the mandate and to consider whether the documents requested, though exempt, should still have been disclosed. And basically, he decides they should have been.
So what is the significant point you're taking from
Well,
this?
the
So
point
the
I'm
judge
making
takes a view.
is that he reverses the judge's conclusions on Section 35. I'm not going to take you through that process now because of time, but it's significant. It's a case, it's one of the leading cases.
Right, but I mean, paragraph 3 seems to be putting the obligation on the respondent. That's the public authority.
Well, this is a...
Sorry, I'm just a little bit confused. Are
Yeah.
you relying on this judgment in support of the proposition that it's an objective rather than a rationality test?
What I'm relying on for is I've actually taken this taking you to this to see what the purpose, policy, and objective of the Act are, which you'll know is one of the issues you have to look at under Section 3,
Yes,
which is the object clause. That's actually what what I'm taking you to see it for. With respect, if I may make this point, I will go to the construction industry case very shortly, which is the leading case on Section 3.
That's the one you keep heralding, is that right?
Yes, that's
right.
the one
Okay.
I keep on heralding. And
Fine.
I'm sorry if I'm taking too long, but
No.
it's really paragraph 8 I wanted to take you to this case for, and it said, there is no dispute that the policy, purpose, and objective of the Act are to create a general right of access to information, limited only by exceptions and exemptions necessary for the protection of essential public interests, etc. There can be no dispute that the court, in both interpreting and implying the provisions of the Act, is mandated to do so purposively to further the policy, purpose, and object stated above. That's what's important. The Act provides for a statutory right to information held by public authorities, and its effect is to broaden and deepen the democratic values of accountability, transparency, and the sharing of and access to information about the operations of public authorities. So that's the passage I drew your attention to. In dealing with a point just made by Lord Sales, the point he made about who the burden of proof lies on is explained by the fact this is a 2008 case. Things have moved on since 2008. It's a very active area of interest in Trinidad.
Well, 2012.
Oh, I'm so sorry, but it's certainly, the case I took you to, the first one was 2019, precisely.
Well, we know that, yeah.
Because it's the most
Yeah.
current case. Now,
Okay.
if I now want to take you to tab 22, which is 1973. I'm not going to read it. This case is of interest because of the approach to frankness and candour, which my lords may recall, it was at one stage a feature of so-called public interest immunity cases. And if I can summarize the submission in a nutshell, basically the courts have said, certainly in Conway and Rimmer and since Burma Oil, that there's nothing in this. A generalized assertion that candor of public officials will be damaged by having to disclose evidence is I may take you to this in a minute, Lord Keith says, it's just of no weight at all. It's this mere assertion. And that, if I may say so, is the essence of the respondent's case. And there is simply nothing in it, absent any factual evidence which actually is convincing. So if we could pick it up, this is the Trinidad version of it, but they begin, I'm at 1988. Paragraph 27, I'm going to take this fairly quickly. Reference to Conway and Rimmer, which my lords will remember was the case effectively deciding that certificates of public interest immunity were insufficient. Lord Upjohn says, I cannot believe any minister or civil servant would feel the least degree inhibited in expressing his honest views. And that's the essential thrust of all the modern cases. You can't just begin by saying, well, they may not like the idea of it. And then Burma Oil, Lord Keith, it's actually, he says, the notion that any competent and conscientious public servant would be inhibited at all in the candour of his writing by consideration of the off chance that they might be produced in litigation is, in my opinion, grotesque. It represents the possibility, seriously impairs even more so. And all of this is directly relevant to our case as well as this case.
Can I just ask, do we know whether Ms. Baptiste and Mr. Chan, who I think you've told us were employees of the company, were they employees of the company at the time they provided their witness statements to the company?
Yes, I think they were. Yes, they were.
Right.
Yeah. And what I want to draw attention to is at 1989, is paragraph 30. Unfortunately, the trial judge does not refer to any evidential basis upon which he based his conclusion. That is central to our complaint. It may be, but probably isn't, arguable that there is particular exceptional circumstances in which there is a danger for the duty of candour. But simply to assert it is, with respect, insufficient. And if I could ask you to turn...
But we've had this before. There was no room for evidence from the respondent before Devine J.
No, my lord, that's true. The point I'm making is this, is the guillotine cannot fall until evidence is given. So it was wrong in principle to refuse leave. Just wrong.
Could you tell me, please, how in this particular jurisdiction the procedure works? You're criticising the failure to put in evidence. At what stage would it have been put in?
Well, I actually set it out in the case, actually.
Yeah.
But, can you just give me a minute to find
it? Yes, I think you do.
But
This is basic. Cutting it short, have we got it right when we have this understanding? This is basically what is still called in Trinidad an ex parte application.
Yeah.
But the judge directed an oral hearing.
Yes.
And he directed that perhaps exceptionally, I don't know, the respondent should be notified of the hearing and invited to attend.
Yes.
So the respondent did attend.
Yes.
But apart from your affidavit, which kicked the whole thing off,
there
was no evidence. And I don't think there was any room for evidence to be given. Is that roughly right?
Well, my lord is right, subject to one possible qualification, which is, I think, as I understand it, from time to time a respondent might put evidence in. But with respect, my point is not about a criticism of a failure to put in evidence. My point is that you can't refuse leave without any evidence.
You're saying the decision is premature.
Yeah, exactly so.
Standing the jurisprudence of the Trinidad and Tobago courts that once you've made this application, you say that the evidence has to come in.
Yeah, it does. If indeed there is any cogent evidence to support it, which the authorities at least suggest that may be a bit of a stretch. It'll be particularly a stretch when I actually analyse Mr. Nelson's opinion, but we'll get there, I promise, fairly soon. Can I just go back? So I wanted you to look at 1990, and sorry, it's the same point, but I think this is quite important for the Trinidadians' point of view. Paragraph 31. There is no factual basis in this case. Accordingly, there is no evidence to support the trials judge's finding that public servants in Trinidad and Tobago do not possess the same level of maturity as their counterparts in the United Kingdom, which will equip them to handle criticism and cause them to be inhibited in the way that they apprehend things. So that's of some importance, I think, given the Trinidad character of the case. And then I wanted to take you to paragraph 34, again, to a discussion of the object. The object of the Act, and this is again an important Trinidad point, the object of the Act is to make information freely accessible. It is an important piece of legislation in a post-colonial society in which bureaucrats have historically been reluctant to expose their decisions to the glare of public scrutiny. The freedom of access to information is also important in a society that is politically polarized along ethnic lines. Well, I hardly need reiterate that is a prominent feature of this jurisdiction.
Yeah, we understand that, Mr. Clayton.
And in which, here it's about appointments to public office or decisions involving the allocation of states' resources are often subject to speculation and mistrust. Against this historical and social background, the right to access to information must be jealously guarded and must not be allowed to be whittled down. Information requested must be provided unless the refusal to access is expressly permitted by the Act and the authority produces adequate and intelligible reasons for the refusal. And then he says that the minutes, which was really about high-level legal advice, the judge was wrong in granting partial access, but that was because this case is decided on its particular facts. It simply reiterates the point which my Lord Hodge repeated a while ago. It is ultimately a question of fact whether Section 35 is overrides or not, and this is just premature. Can I next please take you to probably the most important case, which is in 1802 in the bundle. This is the construction industries case. If we could begin at 1802, please. This is essentially a complaint about the failure to disclose legal advice. You pick this up from the last sentence of paragraph 1, and then paragraph 4, in these proceedings, the minister also relies on legal professional privilege. Then if I could ask you to turn through to 1831. This is the judgment of Justice of Appeal Barreau. If we could pick it up from paragraph 63. It's the court's approach to the interpretation of Section 35, which is of particular importance. If your lordships have that.
Yes, we do.
The approach to the court to an interpretation of Section 35 in particular and to the Act as a whole must be purposive, having regard to its intention. And then reference is made again to Section 3, which is a central part of the Act. Turning the page, 64. It creates a presumption in favor of disclosure in the exercise of any discretion conferred under the Act. And that's the relevance of, I think, Section 3.2.
So where does the discretion come in?
Well, to the extent that there is any.
No, well, come on, Mr. Clayton. Where does the discretion come in the case that we're looking at?
Well, I think
it's an evaluation, isn't it?
It's probably
it's an evaluation rather than a description.
I think that's right. I
well.
may have spoken too soon. But what's said, 64, Section 35 is expressed in mandatory language. It says that's the conferred discretion. Well, there we are. Of course, public interest considerations are paramount, but where the pros and cons are evenly balanced, the presumption in favor of disclosure in Section 2 will tip the balance. That is, the public authority is mandated to give access.
I mean, I think it should be pointed out, Section 3.2 itself talks about any discretion conferred by this Act shall be exercised in a particular way.
Yeah, that's what I was referring to. Well, I'm just picking up what the learned Justice of Appeal has said.
Sure.
Can I ask you to turn through to the next page? 66. The exemptions are set out in sections 24 to 35 of the Act, which protects certain documents. Section 35 then provides that such protection may be overridden where the benefits to the public interest in disclosing them outweigh any damage to the public interest which may result from that disclosure. Inherent in such a balancing exercise is the right of the public authority to refuse disclosure where the damage to the public interest outweighs the benefits. It follows there will also be a good public interest reason to keep certain documents private and undisclosed. 67. This is important. Viewed holistically, therefore, the Act recognizes the conflict which exists between repeating rights, the right to know or be kept informed on the same one hand, and the right to privacy and confidentiality on the other. And in any case, there's a reference to a balancing exercise. And then 69, next page. The intention of the Act in making available information about the operations of public authority is a radical departure from a culture of secrecy and confidentiality which pervaded the public service at the time of the Act's passage. I draw in that regard to my own experience as a legal officer of the public service. Now that's quite important in terms of indicating the cultural context in which we're operating. And then if I could ask you to turn to 1836, please. Paragraph 71. Section 35 applies whenever a public authority has decided a document is exempt. Picking it up from the quote from Mr. Justice Seepersad, rightly found there was an onus on the minister to consider whether there was a Section 35 public interest override. It does not appear that any Section 35 assessment was made in this case. The Council contend this failure was illegal or Wednesbury irrational and amounted to an omission of the minister to perform statutory duties. I think that's the language from the Judicial Review Act, which sets out the grounds for judicial review in Trinidad. It certainly was an omission.
But I mean, if the appeal system is appealed by judicial review, then we have to look at the Judicial Review Act for the grounds on which judicial review can be. Well,
they're pretty straightforward. Illegality, which we would say is a misdirection, which is a misdirection, is the territory we're in. And I wanted to just take you to the next sentence. It certainly was an omission, but only evidence I cannot say it was Wednesbury unreasonable. And then he goes on to say, next page, that there are two limbs. He then refers to public interest and then says the issue in this case, this is the bottom of 72, is whether in the circumstances there is a greater benefit or injury in the public interest. And then says 73, the Section 35 override must be considered by the public authority on each occasion when it determines that a document to which access is sought is exempt. Pausing there, just to go back to a point my Lord Sales made to me before, you can see the word exempt includes the Section 35 consideration. Having found the document to be exempt from the public authority, having found the document to be exempt, the public authority must then decide whether on either limb it should be permitted access to the document. And then if I could ask you to turn the page, please. 74, the middle. This is all deals with limb 1. Limb 1 is the A, B, and C of Section 35. But picking it up from the second thing, the public authority must still consider the second limb before responding to the request. If the decision to deny access because it's contrary to the public interest, this decision and the reasons supported must be stated in the Section 23 notice. No Section 35 override is before in this case. It thus fell to the court to decide the public interest issues.
Well, that may be rather against you, Mr. Clayton, because the April letter of refusal did address Section 35,
Well, I'll come
unlike apparently what had happened in this case. And it was only where there was no address that the judge is saying it falls to the court to decide it.
No, well, with respect, it is not the law of Trinidad that the fact that the public authority expresses a view is irrational, is then considered on rationality grounds. And if I fail in making that submission clear...
Well, you've shown us the very helpful summary, most recently conducted by the judge, of these principles.
But I mean, I think it's fair to say you had been heralding this case as the authority that shows that it's not a rationality test, but as my Lord Wilson points out, 75 doesn't seem to support you so far as that is concerned, because the court seems only to have gone into considering the matter objectively itself because the public authority hadn't done the way
with respect, it's quite important not to overcomplicate these things. I mean, basically what's happened here is irrespective of whether the court, the authority does or doesn't, the same test is applied. And I'll complete the submission when I complete the authority, but it is simply inconceivable if you look at the strength of the views expressed, particularly by the next judgment that I come to, the lengthy analysis of the constitutional context, that it all ends up with a Wednesbury test. It's unsustainable as it's not even put forward as a submission.
Anyway, I think you've got the point that we look at what the Trinidadian judges have been saying, and we understand what the scope is from what they tell us. But
Can I just move on, if I may? What I wanted to do was then very briefly go on to, I think I was at 75. Yeah, 75, it fell to the court to decide the public interest issues in the second limb. And then it said that CPRSAD said it applied, but he does for different reasons. And I just wanted to look at, this is about legal professional privilege, and what happens 75, 1 through 8, maybe more, 9 are the heads which are said why legal professional privilege trumps everything. And if this were a rationality exercise, you would have thought that that might be a very important factor in terms of determining the judge's conclusion. If we come to 77, Barreau says, these are weighty conclusions, but in considering them, I must keep in view the objects of the Act, the intention, etc. He says that with that object as the focus, Section 32 then states that the court should, so far as possible, facilitate and promote disclosure. Then refers to an Australian case, Mr. Justice Kirby, about access to information being significant and exceptional. He then says, 78, picking it up from the sentence at the bottom of the page, in this case, we are dealing with legal advice given by public officers in respect of a project which there are very considerable funds, which are expended. Issues of accountability and transparency are far more significant. That is not the language of Wednesbury. 80. Further, I can see no harm in the public interest in disclosure of the legal advice given in this case. That is not the language of rationality. The proposed development is in respect of state lands valued over $1 billion. The project was an extensive one. The proposed developer was chosen by the ministry rather than the board. That was a complaint about the procurement exercise. Ultimately, the burden of the payment falls on the public purse. Then 81, the last two sentences. Unwillingness to disclose formed by habits of secrecy and self-protection can lead to corruption or a loss of faith in the decision. An open democratic society thrives on the robust discussion of the court of public opinion. Information properly sourced and provided can only enlighten such discussion and educate the uninformed. Again, I draw attention to the cultural context in which this legislation has particular importance. Then turning the page, please, to 1844. Having weighed the benefit to the public interest against the damage likely to be caused by disclosure, I consider that it is in the public interest to disclose the legal advice to disapply the Act. This way, both the basis and soundness of the advice will be tested in the court of public opinion. Rather than shock the minds of right-thinking members of society, it will bolster public confidence if the advice given is sound and reveals a proper foundation for allowing the ministry to invite the request for the proposal. If the advice is unsound, then a defective process will have been thwarted. It is also in the public interest that any advice which is negligent or unsound is revealed and corrected. Now, I draw particular attention to that because of the paragraph 25 of my friend's printed case. If I could ask you to turn to that. I don't know whether you have it separately or in the documents. My learned junior can perhaps tell me where it is in the documents. 1114, thank you.
Yes, we've got that.
This is what Mr. Rowe contends. Disclosure of the witness statements will not, however, help anyone to evaluate whether there's anything in the suspicion for the undoubted fact that the respondent did receive clear legal advice from writing from senior leading counsel against whom there's no suggestion of impropriety that it was likely to lose its claim against Mr. Jones. That fact would not be changed by anyone looking at the witness statement. What he says is that our assertion that there's a common sense basis is respectfully nothing of the sort. But the point I make is that paragraph 84, and I'll take you to, in a minute, to Jamadar, who says the same thing, is a total refutation of the submission that's made at paragraph 25. Why does it matter? And the answer is that transparency and accountability matters. It doesn't matter whether it's under the guise of legal advice or anything else. If I could take you to the, I'm going to go back and then come back, but I'll take you to Jamadar's view on the same thing.
Yes, but everything that is being done here in these passages that you're referring us to, everything there is the court carrying out its own balancing exercise in the context in which the public authority had not done so.
Well, with respect, that...
Yes or no?
Yeah, that may be true, but that is a distinction which really, well, look at the reference I say. There's simply no basis in any of the Trinidad cases for saying that you approach the question of justification under Section 35 differently where a public authority has given an explanation one where it hasn't. There's simply no basis for it. And indeed, actually...
Well, I'm so sorry, but paragraph 75 of the judgment you've just shown us...
The first sentence.
And the second, it thus fell.
The second sentence, sorry.
There is a power where there is no... where there is no explanation about Section 35, and maybe someone else can find this for me, but it's said in the judgment, for it to be remitted back to the court, to the public authority, to look at it again. That's certainly the position, if it hasn't ever looked at Section 35. That's not this case.
So are you saying that although on the facts of this case, it was a situation where the public authority had not conducted the Section 35 override balancing exercise itself, you gain support for your submission that the proper approach for the court is to conduct the balancing itself when the matter comes before it, by reason of the fact that the court here could have remitted the matter to the public authority to consider for itself. Yeah. But it didn't.
It didn't. That I do say, but I also make a more fundamental submission, which is that we have been unable to find any authority for the proposition that the distinction should be drawn in cases where there is an authority that gives an explanation and one that it doesn't, on the basis of saying where it has, it's a Wednesbury test or rationality test, and where it hasn't, it's basically an equality test. The position is the same in both sides. Sorry, Mike.
The authorities.
Yeah, well, I'm also reminded by Mr. Knight, and this is very clear if once we look at the judgments themselves, that even if it is a rationality test, which I don't accept it is, one has to assess the rationality against the balancing exercise that the body's actually undertaken. And I'll demonstrate that no consideration of the benefits.
Of course, if there is a difference, substantial difference between when the authority has conducted a I'm so sorry.
I'm so sorry.
I'm so sorry, Mr. Clayton. You take instructions.
Okay. I'm told, sorry, forgive me. I'm told that a case, this is actually at 1231, but this is a case where, again, Mr. Ramlogan was counsel in this, but this was a case where there was, they did consider Section 35, the public authority, and the analysis that the courts developed.
1231.
1231, beginning there. It's about unfair promotion and information which relates to appraisal reports and so forth. And everyone gets that from page 1231, 1232. It's about reports.
Yes, which paragraph do we go to?
Can I ask you next to turn to 1249?
Yes.
Which says that the exercise has been undertaken by the defendant. If you could read that, please.
Which paragraph?
54. But the defendant has, by his letter, stated that consideration has been given to Section 35, override in favour of the discussed. He then explains that there'll be less candour and frankness in the report, so it's rather similar.
And then where do we get the court statement of the... Oh, I'm sorry.
So I'm trying to read this as quickly as I can, sorry. The submission appears at 62. And then, is this not the conclusion? 67.
Yes, I think you want 63, don't you, Mr. Clayton?
I may well, yes. I think, yes, that's from the same case we were just looking at.
So they've given their Section 35 reasons.
Yep.
And here's the judge saying they're no longer applicable or relevant.
Yep.
She does the benefit analysis, both sides.
Yep.
Turning over. Not wholly unarguable. Although it's clear the defendant expressly purports to consider the Section 35 provision, it exercised its discretion wrongly, which actually ties in with the question that I was going to put to you before you took instructions, which is, if there is this big difference between when the public authority has done a Section 35 exercise or not, what if it does a colourable one or a superficial one or pretends to have done one? So it's difficult.
Well, with respect, I'll come back to the case in a minute, but with respect, I accept the point that my Lord has just made to me, and that's precisely why I make the primary submission, is that a host of different approaches do not arise out of whether
well,
or
quite.
not. Because as my Lord effectively makes, you could have a gradation or spectrum of answers, and when does illegality shade into rationality? It just becomes unworkable. And I mean, it's worth pointing out, if I may, at page 1254, it said a declaration, the decision to refuse or deny access without due consideration to Section 3 is illegal.
I'm sorry, where were you reading that?
I'm reading, in fact, from 1254.
Yes,
Paragraph.
That's the order. The declaration is that it's illegal.
So have I understood the judge here is simply carrying out the assessment exercise for herself?
Yes.
Despite it having been carried out by the authority first?
Well, there are several stages to this. What's been put to me is, well, is there a difference does the judge approach the question differently if the public authority has in fact carried out a proposal? And the submission I've made to my lords and lady is that the approach is the same. It's not a rationality test, it is an illegality test, hence the declaration which I've just referred to.
I mean, the order seems rather ambiguous on the point that we're struggling to understand your submissions on, as to whether it's an objective test or a rationality test, because it actually says decision to deny access to the requested documents without giving due consideration to the provisions is illegal.
Well,
that's a failure to carry out a statutory remit.
Yes, it is.
Yeah.
I mean, it's not, with respect, it just isn't a rationality test. I mean...
Well, but illegality in that context, is it not? It's a failure to carry out a statutory obligation.
Well, it's without giving due consideration. So it's actually what it's saying. I mean, analysing the prayer perhaps is a bit... But anyways, what it's saying is without due consideration. So it's not saying there was no consideration, but it wasn't a proper consideration.
And rather than the court making its decision, they remit it back to the decision maker. Why do they do that if the court is entitled of its own accord to come to a decision?
Well, one's handicapped by the fact that we're dealing here with a jurisdiction which produces a lot of cases, and I haven't brought every single case that's here. Circumstances dictate different results. My lords will know the judicial review is always discretionary in terms of relief, and there may be circumstances in which it's more appropriate to make one order rather than another. But with respect, the important point I take from this case is that without due consideration is hardly Wednesbury language. It's not. It's simply saying, the question of whether a decision is arrived at, which a reasonable authority could arrive at, is a different one from saying that the failure to consider it in an appropriate manner results in unlawfulness. It's just a different exercise.
Anyway, of course, leave had been granted in this case, in the Bessessar case.
Yes.
And this was a full judicial review.
Yes, it was.
So all this is down the line. The ultimate order that you may or may not get, were you to succeed on this appeal, is all down the line, really.
It is. And that's the prematurity argument.
But
Yes,
surely,
they will.
oh, I'm so sorry, but surely we need to understand the test that is to be applied ultimately in order to see whether you have an arguable case at this stage.
Well, can I make two different suggestions? One is that we park this till I actually get to the facts of the case, because it's really pretty obvious, in fact, however you look at it, that leave should be granted, because it's so weak what's said. But that may be false for me to put it that way, but that's the way I would put it. And can we just return to it? But the only point I want to make, and really make vigorously, is there is simply no support in the Trinidad cases for the rationality argument. This isn't there.
Right.
And in that context, if I may say so, in the Privy Council, where one has to be sensitive to the cultural issues which have been repeatedly made by Barrow, and I'm about to come to Jamatar, the constitutional background and so forth, in our submission, the board should be slow to interpose a requirement which may make sense from an English perspective, but is inappropriate to the cultural setting of Trinidad for the sort of reasons that I've set out, actually set out by Barrow when I was referring to this cultural secrecy, ethnicity, and so forth.
Well, I fully see the force of that, but ultimately we have to rely on the Trinidadian jurisprudence to find out what tests they do apply. Yeah. And at the moment, I cannot say that I have found the answer very clear.
No, well, it may be that was imperfect foresight by us in anticipating. I mean, all I can say is, as I understand it, there's simply no basis for it. Now, it's always impossible to refute something which, the closest we get to it, as I've understood it, and we've tried to deal with, but there is no basis in it. It may be that if I may respectfully suggest, that the court, when it sees the facts, can defer the consideration of what the appropriate test is to the trial judge, because if on the immaterial leave should have been granted, and I'll submit that in due course, then it really may be premature at this stage for my lords to have a concluded view on what is obviously an important issue of legal principle.
Mr. Clayton, you've got 3/4 of an hour left.
Yep.
You haven't dealt with the facts.
Nope.
They are, you say, important.
Yep.
On the other hand, you did want us to go to the judgment of Jamadar J.A. in this case.
Yes, I did.
We've already read one clip of it
Yep.
because it was quoted by the judge 2 months ago in the first case you showed us.
Yeah.
But so perhaps getting a move on a bit.
Well, can I just...
What else did you want to show us in the judgment of Jamadar J.A.?
Sorry, what's it's something wrong. I'm going to take this, well, I'm going to take this quickly, if I may. Where does Jamadar begin? Can you remind me? The judgment begins in 1848 of Justice of Phil Jamadar. And I think what I might do is, if I may, is simply invite you to read the relevant paragraphs in due course.
Yes, that would be very convenient.
Will you
Which
state-
are they?
Will you also state the proposition which you rely on
Sure,
for
okay.
those?
I'm trying to do this as fast as possible. Okay, I think we start...
It's 1847.
We start with at 1857, please. There's the agreement about paragraph 22. The statutory underpinnings are important. The 22 and 23 emphasize the Section 3 tests about necessity and the essential public interests. 26 deals with 5 principles, which focuses on the requester's rights. Paragraph 29, which is developed at some length indicates the constitutional underpinning of the Act. That's 29. There's a lengthy discussion of the preamble, which I won't burden you with. Page 1865 is dealing with the protection of essential interests, refers to the balancing exercise in the context of the above stated statutory.
Now, we've read that because it's quoted by the judge recently.
Okay. And then we're told the relevant question is whether on the available evidence it's justifiable. That's paragraph 41. Then paragraph 44, again, references to the constitutional value of participatory democracy and upholding the rule of law, prima facie in the public interest to disclose. That's 44. Then 46 refers again to the historical context and social circumstances. Roman 2, which is 1867, the suggestion there's a chilling effect is both pessimistic and flawed. Bottom of the page, hard to accept public officers being inhibited to give frank advice. Then turning the page, reference again to Lord Keith in the Burma oil case, Conway and Rimmer. And then at I've taken you already to 169. Then 1870 of the opinion that the public interest, transparency and accountability far outweigh any damage that may be caused. So again, a factual exercise. 47. Yeah, 47. Yeah, 47, I'm so sorry. Okay, can I now deal with the facts relatively quickly? I'm not going to develop any of the other submissions which you make either about the test for judicial review, they're in the submissions, or on the material that's there. What I want to look at, first of all, is the request and the answer, which we'll find it's 711. So, can I just put some papers away?
Yes, of course.
So 711 is the request. Yeah, if you have 711, you can see instructed at the bottom of the page about the Attorney General gave instructions to discontinue the 1.2 billion claim brought against Malcolm Jones. And then if you turn the page to 712, middle of the paragraph, after the judgment delivered by the London Court of International Arbitration, and all witness statements filed in that case. That's the request made. And then if we turn through to 716, sorry, this is the answer. They provide the judgment, but the second request is refused. They rely on section 32, this is what they say about it.
I'm sorry, which page are you on now?
On page
716.
716.
Thank you.
So this is the decision letter, in fact, isn't it?
Yeah.
Effectively, yeah. That's right, this is what was judicially. This is information to exempt disclosure would be contrary to the public interest. If the benefits to be given in the witness statements of confidence be disclosed, future potential witnesses will not be willing to give evidence. Similarly, arbitral proceedings are confidential, and the arbitration court, which receives the witness statement given, but will not in future be willing to provide arbitration services to Petroleum. The second disclosure, if granted, would destroy the usefulness of the rules of the London Court of International Arbitration. They then refer to Article 30, which actually doesn't have the effect of Article that in a minute, which they say it does. Wrong. And then they refer to paragraph 30, section 35, this is at the following page, 717. Consideration is being given to the overriding public interest of the Freedom of Information Act, having regard to any benefit or any damage. Disclosure is not justified in the public interest, and damage will be done to the public interest, which encourages against the settlement of differences. Disclosure would jeopardize the usefulness or availability of that procedure, likely to deter witnesses. Well, that's all assertion, but what you'll note is nothing said about benefits at all. Nothing said about the benefits of disclosure. I'm dealing briefly with the point about Article 30, where they're just wrong. If I could ask you to go to 738. You can read, if you've got that. This is the confidentiality provision of the...
Yes, we have got it.
Okay, well, it states the parties undertake as a general principle to keep confidential all awards together with the materials, etc. Save to the extent that disclosure may be required of a party by a duty. Now, Section 11 imposes precisely that duty. So the idea that they take any sort of comfort from the article is somewhat surprising. Then, can I just go through some dates? And again, I'm going to take this fairly quickly. There is an arbitration which is on the 4th of December of 2012, which is the ICC arbitration between Petrofin and WWG. We don't know much about that because we haven't been told next to anything about that at this stage of the proceedings. What is important, however, is an opinion from Mr. Nelson on the 1st of March of 2011, and I'd like you to turn to that. That's 608, please.
Yes?
Sorry, what I'm going to do, because of time, is invite you to look at this at more leisure. But the short point is this.
It's paragraph 26.
Yeah, and also, it should be said that it looks at a whole load of his advice. And it's worth noting that there is a second opinion which immediately follows behind it from Mr. Marginal, but I'd also invite you to read it at leisure.
I think we've noted paragraph 6 of Mr. Nelson's first opinion. The most obvious failure to exercise due diligence was the board's approval in about September 06 to enter into the guarantee of the other company's obligations, Mr. Clayton.
Yes.
Actually, I think the guarantee was dated, it doesn't matter, January 2007.
Yes.
But that is the, as I understand it, the main feature, negligence in and about the execution of something in January 07.
Yes.
And we will soon see whether it's that particular allegation with which Mr. Martineau concurs.
Yes, well, he does say he agrees. He deals with the law. I'll just take these.
I was thinking of the last paragraph of paragraph 24 of his opinion, which we find at 625. And therefore at one with the conclusion of Mr. Nelson on the director's liability for negligence in relation to the guarantee.
Yes.
So that's a 2007 point, Mr. Clayton.
Yes, well, yes.
And we must bear that in mind when we look at later material.
What I next want to look at, please, is the defence to the proceedings, which I particularly want to look at paragraph 20.
Sorry, just before you do that,
So,
page 615, just before we leave this letter.
615.
Yeah. Sorry, can you just tell me what's happened to the paragraph numbering? Is something missing here between 19 and 25?
Yes.
615.
No, 615. There seems to be a page missing between 615.
Yes. 763 goes to...
Well, I think we'll have to take steps to get that to. I'm so sorry. You're right.
May be important in the light of
No, it may be, and we'll
It's
obviously.
more than one page
It's,
missing.
it's 6 pages.
It's 6 pages if you look at the numbering at the very bottom.
I'm obliged. Well, I can only apologise profusely and say we'll get it to the board. The next thing I want to look at actually was the statement of claim in the High Court, which was issued on the 19th of April 2013, and which you'll find in 107. You have 107. If you see what's called the phrase overview, much favoured by people.
Yes, we do.
If I could ask you to read paragraph 1D, first of all.
I'm sorry, which page was that?
107. That explains the case. Then I'd ask you to turn to, please, to 140, which leads breaches of duty, which is important.
114.
140, please. And you can see, well, I'll ask you to read it through. They're in some detail.
What do you want us to read then, Mr. Clayton?
I want you to read page 140 onwards, which is the breaches of duty. These are the breaches, the complaints against...
Well, how far?
They're only 4 pages, but or you will perhaps note them, but you can see there's quite a... There's a lot of specific over-applicant complaints about his role as the executive chairman, and they run on until page 144. So perhaps you can look at them again later. But those are the actual allegations made against Mr. Jones.
Yes?
Then I want us to turn to the arbitral ruling, which we find at 459.
Yes.
And you'll note, sorry, that if you read the judgment, I think, this is at page 459, paragraphs 1 through 10 explain the background to the case. It's actually notes 1 through 12, and I'm not going to read it to you, but that's for your note. And the short point is that none of those issues are to do with Mr. Jones's conduct. That's the short point. And then if you turn through to page 463, at C, you can see the two statements of the two Petrotrin employees. That's at C, and Baptiste and two.
I'm sorry, I missed the page.
463.
463, thank you.
There are four, I'm told. There are four different witnesses there.
Sorry, where are you on the page?
463, C.
Witness statements.
Witness statements responded.
Ah, right, yes.
Those are the witness statements. So that's in 2014. These are important dates. On the 7th of September...
Well, sorry, there are more than four, aren't there? Because there are two lots. There are going to be 8.
It's the same people giving two statements of different dates.
Yeah, four witnesses, two statements each. Sorry, I'm just trying to get...
Thank you.
On the 7th of September 2015, there's a general election and change of government, which is important because on the 8th of October, Mr. Jones is appointed by the new government to the Cabinet Standing Committee on Energy. So that's notwithstanding the litigation. And there's a new board of Petrotrin, and on the 11th of October 2015, we have the key opinion of Mr. Nelson, which is at 457. That, please?
457.
Yeah, I think so. I'm so sorry, it's 547.
Yeah, well.
Okay, and the attachments earlier advised. What's of some significance, given the position adopted by the respondent, is Mr. Nelson advises on the disclosure issue. The disclosure issue is whether these witness statements should be disclosed to the High Court proceedings. And he effectively advises, picking it up from the bottom of 548, in my view, the court will order the disclosure of the relevant documents. So he takes the view, so that's important as a background fact. And then he says, it's really paragraph 6 onwards, which is the important bit. Having considered them carefully, he refers, consider the contents of the witness statements which were not available in 2011. Having considered them carefully, there is a basis for concluding that the board, through bad business issues, found itself committed to the invention. He says they were naive and probably duped and so forth. He says Mr. Jones will testify at trial. A court may very well find that the decision which is taken to achieve this was a bad business decision. However, a distinction between bad business decisions and negligence, that is what will engage the court. I understand that is the channel of convincing witnesses at the arbitration. No reason to believe that we can be convincing at this trial. In those circumstances, there is a reasonable likelihood that the court will be persuaded that there was a bad business decision, but no negligence. This is a matter for the board to consider. The short point is that none of those issues were central to the arbitration.
You've not read the sentence beginning 7 lines down from the top of paragraph 6, and I had expected you to do so, Mr. Clayton. Once the board discovered, have you got that sentence? Once the board discovered how deeply committed Petrotrin had become, it appears from the statements of the two, well, he calls them directors, you say they're only employees, that the company did what they could to protect Petrotrin's assets. And so I wondered whether you were going to submit, because nobody has seen these witness statements yet, that they were dealing with a period long after the entry into the controversial guarantee.
With respect, my lord is entirely right. I mean, the difficulty is, and this is a slightly broader point, is this is a very vague opinion. And if you look at the detail of the duties pleaded, which I took twice, it's a very perfunctory way to deal with this, but especially when one bears in mind the fact that the arbitration proceedings were about completely different issues. In particular, our first point is it's far from self-evident that witnesses in one set of proceedings would be central to the proceedings against Jones. That's the first point. The second point, which again is difficult to understand, is you haven't yet read, but you will, I'm sure, the Nelson First Opinion. That's primarily about documentation, which is very extensive, and it's actually a longer opinion than I realized because there was more to it than that. And it's all about the wealth of documents which cause concerns. And it's frankly very difficult to understand how those documents, documentary material referred to in that opinion, was displaced by these witness statements when they had nothing to do with the case at all. It's very difficult to understand. So what we would respectfully submit is that such a vague and unspecific witness statement, which on the face of it is about a different set of proceedings, doesn't meet the obligation to achieve transparency or to secure accountability. You'll remember that the passages I took you to from Burrow and from Jamadar about the refutation to paragraph 25 of Mr. Rowe's submissions. So the short point is that in our submission, in a complicated case, which it clearly is, with a lot of documents, to describe just in general, without reference to anything, why this was decisive, it would result in public disquiet. And that becomes particularly important because the Attorney General, it was the Attorney General who announced the discontinuation of the proceedings against Jones. For your note, that's at 553, and that was on the 1st of March of 2016. And then, completely unprompted, on the 9th of March of 2016, the Attorney General referred his handling of the civil claim to the Law Association, to his there's a press statement about that at 643. No Attorney General, and there have been a few, many of whom have had the pleasure of appearing before the board, has referred themselves to the...
What was the upshot of that, Mr. Clayton?
We don't know. This hasn't been resolved yet. It's still ongoing. But on the face of it, these are very disquieting facts. In relation to an opinion, which you'll forgive my saying so, is really very thin, particularly having regard to the previous opinion. So, what our case really comes to is, I haven't taken you to the two passages. Can I do that very quickly, the two judgments, which are at 836. Could I ask you to show through the 844? It starts with 844. He deals with it. What he's done is taking the subheadings from the Judicial Review Act. But this is where he goes with section 35. Paragraph 35, he recites its term. Paragraph 26,
so paragraph 25 again discusses the implied obligation of the confidence not to make use of material generated in the course of the arbitration. That, with respect, is difficult to understand because the implied obligation must be trumped by the express obligation in Article 30. And Article 30 expressly requires someone under a legal duty to provide documents. He then, he recites at 29, 28, the article that fails to pick up the fact that someone under a legal duty has to respond. But the critical problem is, nowhere does he discuss the benefits of disclosure. Nowhere. All he does is repeat the respondent's case. And that, with respect, is a plain misdirection. And then if we go to the Court of Appeal, which is at 924.
Sorry, but just on that, what about the first sentence of paragraph 24? It's well settled by many authorities. The intention of the FOIA is to promote disclosure of information held by public authorities to the public.
So, can you...
Paragraph 24, he seems to set out or summarise some of the propositions that you have given us.
Yes, but what he fails to do, and I'm going to conclude my submission by taking you to the benefits, is this is supposed to be a balancing exercise, weighing one side against another. Where in the scales does he discuss the benefit of disclosure? Not at all, is the short answer. Not at all. And then the Court of Appeal judgment is even more profound. It's 924. If we could turn to that, 924. And you can see there that there's no discussion of the benefits. And that's a statutory mandatory consideration under Section 35. There's not. That's, again, a plain misdirection.
It's page
94.
Yes, but what you're saying is the Chief Justice may be addressing Lim 1, but Lim 2 doesn't appear.
No, not at all. And the case is, I should have made this point, but if it wasn't obvious, I should make it now. That if you went from the request from information, it's always obvious that Lim 2 is in play. It's always obvious from the request.
But surely the essence of the Court of Appeal's judgment is they've looked at the judgment of the judge at first instance and they're satisfied he has done the balancing test. I appreciate you criticise that, but that seems to be the Court of Appeal's view. And it being a review jurisdiction in the Court of Appeal, they will not interfere with the judge's assessment.
Well, it's difficult to see how he could have been satisfied about the exercise being properly conducted when a huge chunk of it was missed out. I mean, it's not a complicated section. It does say you have to do a balancing act of the harm, of the benefit of disclosure against the damage. And in reality, this is a case where there's very little damage because the broad assertion that there's going to be that there are problems about disclosure of the witness statement evidence in the arbitration is simply an assertion. And for the Burma oil case and so on, that's with respect very difficult to follow. So there's minimal damage and no discussion of benefits. And that simply won't do. There's no rule which says, well, Section 35 mandatory considerations don't apply to a leave consideration. And it's particularly important to realise the political context in which this is operating. This is a £97 million US claim in the context of a $3 billion loss. People are concerned about it. They'd like to know why has it been dropped? And I want to conclude my submissions by pointing out the benefits which have been missed out.
So it's your submission that even the Court of Appeal on reviewing the judge at first instance decision itself has to carry out a balancing exercise?
Well,
rather than just saying that he isn't plainly wrong. Are you going that far?
I think actually on the authorities that I probably do go that far, but I don't think I need to. I think all I need to point out is that at first instance, there's no balancing exercise being conducted because he's not weighed benefits against detriment effectively. And therefore, it's difficult for the Court of Appeal to have endorsed that approach.
absent the benefits itself and assessing the benefits. And it didn't do that either. So in our submission, with respect, it's clear from either point of view that the balancing exercise in Section 35 never happened. And as I say, damage is at the low end of the scale for the reasons that Lord Keith said in Burma Oil, which is a long time ago. And particularly so when one remembers the culture of secrecy in a post-colonial society, which both Barrow and Jamadar attach great weight to. But as I say, I want to conclude by making some points about what are the sort of benefits. Well, the first benefit of disclosure is to ensure transparency, public understanding, and public confidence in state decision-making. And in that context, there are 8 subpoints that ought to be recognized. 1, the disclosed legal opinion and the wider justification given publicly for the withdrawal of the claim is based solely on the witness statements in the arbitration proceedings. That's it. 2, the arbitration proceedings was about different legal issues and was not concerned with the actions of Mr. Jones as alleged in the Petroleum statement of claim. Sorry, forgive me, it's the claim against Jones. The opinion itself doesn't say in terms, and indeed doesn't advise against disclosure to the High Court proceedings. This is Nelson's second opinion, and in the context, it's difficult to see why, if it's being disclosed to the High Court proceedings, in which case they would become available for the public to see, subject to any orders to the contrary, which Nelson doesn't say need be sought, why he draws a distinction, or why any distinction should be drawn based on it, from the High Court on the one hand, and the Freedom of Information regime on the other. Fourth, the opinion does not explain, because it is so vague and unspecific, the following: what issues arise from the evidence of the witness statement? Second, what evidence undermined the claim against Jones? Third, how the witness statement on issues in the arbitration are said to be relevant to the different interests in the Jones action? Does none of that. Or even formally advise the withdrawal of the claim. It's also worth noting, although we haven't had time to look at it, that the arbitral award itself, this is 4, does not make any factual findings or address any witness evidence at all. So it's just difficult to understand how these could have been so key. Fifth, the public had been made available of Petrotren's pleaded case, the legal opinions, and the opinion giving rise to the concern about evidence, and is able to evaluate for itself the evidence in a relevant context. Now, it's important to appreciate that the government felt required to waive legal professional privilege in the opinion. That, in our submission, is a weighty factor in terms of assessing benefit, and indeed the government's own view. Sixth, the withdrawal of the claim was of such obvious public importance and controversy because it was announced by the Attorney General himself, not Petrogen, which is a bit odd. The Attorney General, as you'll see from the press statement, uniquely referred himself to the Law Association for his handling of the case. Why on earth would you do that? And seventhly, in relation to the points I was making before, the beneficiary of the decision, Johnson, had been appointed to the government standing committee as an advisor just days before the legal opinion was provided to drop the case. That inevitably is going to create public concerns. Second broad point, benefit, it would enable the board of Petrotrin to be held to account by the public. In that context, 4 points are of importance. The Petrotrin is a state-owned company and a major employer, spending and losing public money. And one point which you haven't been told of because Mr. Ramlow is, but I'll fill this in, is Petrotrin has now fired all its staff. It was one of the largest employers in Trinidad. 6,000 staff were fired, which for Trinidad is a huge loss. And all of this was a direct consequence of the financial mismanagement which resulted in this litigation, or this litigation concerns. It is naturally a very real concern for people in Trinidad. More specifically, people are asking themselves, why was a claim to recover £97 million of public money withdrawn? What was the justification for that? And that's made worse when the failed project caused Petrotrin to lose US $3.3 billion in losses and led to the collapse to which I just referred. That for Trinidad is big money. It's indeed even for the UK, in our straitened circumstances presently. Fourth, the Petrotrin ended up paying the cost of the litigation without establishing its facts, so that the claim was unfounded, based, as I say, on witness statements which had nothing to do with the issues in the arbitration. Thirdly, and I take this out of the construction council case, in a constitutional participatory democracy, enabling the public to press for Parliament to hold Petrotrin and ministers to account for their respective roles and decision-making. In other words, it's part of the participative democratic process, which Jamadar in particular emphasized, that the public should be able to press, if appropriate, if there's something's gone wrong. He laid particular stress on that in his judgment. And fourthly, and importantly, last but not least, we would submit, the rule of law will be served by the vindication of the public concerns or by showing they're unfounded, not by secrecy. That is perhaps, in fact, the most important point of all. And that is the general thrust, not only of freedom of information in this jurisdiction, which is slightly more nuanced and rather different in style, but particularly so for all the cultural reasons I enumerated earlier about Trinidad. My Lord, it's our submission that there were obvious public benefits to disclosure, which somehow didn't find their way into the judgments of the judge in rejecting leave, and certainly didn't find their way into the judgment of the Court of Appeal. And what's worse, there was no evidence, and it's not criticism about the process, but there was no evidence to support the generalized concerns about damage from the arbitration. Subject to that, may I just inquire whether I've missed something of my various colleagues?
Of course you can, Mr. Clayton.
My Lord, I think I've overrun by 5 minutes, but
I don't think you have.
No.
I thought that I saw a timetable saying you were going to sit down at 20 to 1. In fact, there's a revised timetable giving you an extra 5 minutes.
Right.
So you would have another 10 minutes, but you have completed your submission.
I think, subject to any questions from my lords and lady, I think I have.
Okay. Questions? Mary? We have no questions. Now, in normal circumstances, Mr. Ramlogan, we would invite you to follow, but we've discussed this, and in the circumstances, your team has made the decision that it's all been said. So thank you very much indeed. Well, Mr. Rowe.
Well, can I start with what I would call the Section 32 point, because your Lordship expressed some concern about the concession in the Court of Appeal as regards the applicability of Section 32, although my learned friend has very properly made clear that that concession is not sought to be resiled from for the purposes of this appeal. My Lord, if we go first of all to what was said in the Court of Appeal, can I just show you that, and then we'll go to Section 32 itself, and I'll seek to explain why it was a concession that was rightly made. Not in any event that it's one that's being sought to be withdrawn, but I can see why your Lordships might want to be sure about that in any event. My Lord, the transcript of the Court of Appeal your Lordships will find in, and your Ladyship will find in volume 2, tab 9, I believe, which is electronic page 912. And if one turns in that to page 915, we find ourselves in the argument being put by my learned friend's predecessor. Mr. Samlal. And line 14, or 13, I think it is, the Chief Justice says, just so that we're locating this argument in its correct context, is it correct that we're dealing here with documents which are prima facie exempt? The question is whether there is a Section 35 override. Certainly, my Lord. Okay, good. That is the context in which this application must be dealt with, my Lord. So that was the clear understanding of the parties at that stage, whatever might have been the position earlier on. But, my Lord, can we then look briefly at Section 32, which in Volume 4, the first of the authority findings that it set up the board in the same way it is for me, at page 1156, behind the first tab. Just before we look at the text itself, I think it's common ground that the statements we're concerned with are witness statements which were given by employees of Petrotrin in the arbitration proceedings, and they therefore would presumably have been documents that would have been prepared in the usual way that witness statements are prepared, that's to say by a proof of evidence being taken and then converted into a statement. So it was information that was communicated by the employees to Petrotrin for the purposes of being put into the witness statements. Your Lordship may say, well, yes, but it's Petrotrin who then deploy them in the arbitration. That's right, of course, but the information itself is information that's given by the employees to Petrotrin for the purposes of its use in the arbitration. And so, in our submission, if one looks at the elements of Section 32, it was correct to say that the elements, the ingredients that you need to get within Section 32 were all present. This was information that was communicated in confidence by or on behalf of a person, that is to say the proposed witnesses, to a public authority, that is to say to Petrotrin. It's common ground that Petrotrin is a public authority. It was communicated in confidence because of the fundamental rule that arbitration is a confidential procedure. And one does not expect that what one says in evidence in arbitration will ordinarily be made public because the whole process is a confidential process.
But we're focusing, aren't we, on the prior stage of the provision of the information to Petrotrin by its employees. So isn't that such confidentiality as there is, does that not come out of the relationship between Petrotrin and the employees, not from its relationship with the opposing party in the arbitration?
My Lord, it might be said to come from both in my submission. I take the point that as between the employee and Petrotrin, it might be said, well, what you do with it is strictly a matter between the two of us. But of course, in circumstances where one is giving the information for the purpose of its deployment in international arbitration, it's surely implicit in that the confidentiality of the arbitral process will apply to what one says. And so in my submission, both are in play there. And for that reason, insofar as it was accepted in the Court of Appeal that element, implicitly that element of Section 32 was made out, that was a thing that was correct to accept. Then we go on to B, disclosure of the information under this Act would be contrary to the public interest by reason that the disclosure would be reasonably likely to impair the ability of a public authority to obtain similar information in the future. Well, the argument there, which again is now common ground, is that if witnesses who are approached to give evidence for the purpose of arbitration think that the ordinary rules of confidentiality are liable to be lifted, they may be less likely to produce, to comply with requests to produce such evidence.
But isn't that when we get into the authorities that Mr. Clayton showed us about public officials can be expected to supply information? That's why I asked the question, are they sort of still, or were they still employees? So they're subject to a obligation under their employment contracts to assist their employer provide information.
Yes, I'm not sure I'd entirely concede that they were public officials. Petrotrin is or was a corporation.
All right.
Albeit, it's a corporation which is owned by the minister, or was owned by the minister as a corporation sole. The minister as a corporation sole owning Petrotrin. But in broad terms, it's a nationalised industry. So it's different in that sense from.
All right. But they're employees of Petrotrin.
Yes.
With, one would expect, obligations under their employment contract to provide full information to assist Petrotrin really in any aspect of its business.
Well, my Lord, that may be right in the particular case of the witness statements that we are concerned with, but of course the part of the rationale, and I'll come back in a bit to the correct test, which is important because we disagree, I think, about what the test is between the two parties. But leaving that aside for the moment, in this context, the Section 32(1)(b) is concerned with the wider public interest, and so while it might be right, I don't concede the point, but I can see what your Lordship says, to say that in the particular context of these individuals, there were these other factors at play, namely that they were employees of Petrotrin, and perhaps that meant they had some duties towards Petrotrin, or perhaps arguably some public duties. It depends on the precise circumstances. That doesn't change the fact that if there is in general a practice of disclosing the contents of material communicated for the purposes of providing witness statements, then it will impair the ability of Petrotrin or any other body in a similar position in future to enter into an arbitral process, because if it becomes the practice that people can use the Freedom of Information Act after the event when there's been an arbitration to find out lots of information that otherwise would have been kept confidential, that may deter people from coming forward. And those other people might not themselves be employees who can be compelled to do so. That's the point. It could be other people.
But, Mr. Rowe, a company can only speak by its directors and employees. When its employees gave these statements, this was Petrotrin speaking. It wasn't a third party speaking to Petrotrin.
I'm not sure I'd accept that, my Lord. A party who puts in evidence is not speaking thereby. These were witnesses. They may, as it happened, have been employees, but they were individuals giving their evidence as witnesses. They were not in the arbitration as representatives of Petrotrin. No. They were people giving evidence. But my point about 1B, as I say, Section 32(1)(b), is that the question is there a likelihood that would the disclosure be reasonably likely to impair the ability of a public authority to obtain similar information in future? And it was conceded, and in my submission rightly, that it would be contrary to the public interest for that reason. That doesn't mean to say, of course, that under Section 35 there couldn't be an override. That the scheme of the Act seems to contemplate that you can have something which is, at one stage in the analysis, contrary to the public interest, which in this context must presumably mean contrary to the public interest in one respect, or some respects, but which nevertheless, when the final balancing exercise is done under Section 35, is considered to be something which the overall public interest requires to be disclosed. That seems to be the only way one can make sense of it.
Yes, but that seems to suggest that one might just get over the hurdle in Section 32(1)(b), so that one is dealing with a document which counts as an exempt document, but only just, and that when one comes to the Section 35 balancing of the different interests on both sides, that if you're dealing with a case where you've only just got over that hurdle, that's a rather lesser point to put in the balance than if you're completely over the hurdle and right in the heartland of what is protected by Section 32.
I can see that argument might have some force in certain cases where there was a real genuine controversy about the extent to which the public interest was damaged by the disclosure under the Section 32 aspect of it, albeit it was accepted that it was, as it were, over the Section 32 hurdle. I'm not sure I'd accept that is this case, where it was common. It is certainly, since the Court of Appeal, has been common ground that Section 32, that the Section 32 hurdle has been got over. But I entirely take the point that when one comes to the Section 35 balancing exercise, then it's in the nature of a balancing exercise. You look at the weight on each side. My Lord, can I also deal with the provision at Section 32, subsection 2, to which my learned friend was taken, I think, by Lord Wilson in the course of his argument. This section does not apply to information A, acquired by a public authority from a business, commercial, or financial undertaking, and B, that relates to trade secrets or other matters of a business, commercial, or financial nature. The reason that subsection doesn't apply so as to disapply Section 32 lies in the conjunction and. It doesn't apply to information which is A, obtained from a business, commercial, or financial undertaking, and that relates to trade secrets or other matters.
Mr. Rowe, I raised that point. I think you may have dealt with it.
But just so I can understand the structure, I mean, I follow the argument that you make as to why it really has no bearing on what we're dealing with. But it just seems strange saying this section, which is defining what's exempt information, does not apply to trade secrets. Usually in freedom of information regimes, it's precisely trade secrets and the like which are exempt and then have to be taken into the public interest balance.
Well, my Lord, the answer to that may be because other provisions of the Act have more specific provision. For example, if one looks at Section 33...
There are exempt documents listed in...
There's a series of other provisions.
33.1, including D, 33.1D.
Yes.
Information obtained by a public authority from third party who is consistently treated as confidential.
Yes. All right. Yes, thank you.
So I think the answer is if you're in the territory of information acquired from a business, commercial or financial undertaking that relates to trade secrets, other matters of business, commercial or financial nature, then you don't look at Section 32, but you look elsewhere.
Yes.
Section 32 doesn't tell you whether or not it's exempt. It just says look elsewhere in the Act to find it.
But it might be of note, Mr. Rose, that really to get the 32.1 concession, we're talking here about 32.1b, and the test is whether it's reasonably likely to impair the ability of the authority to get the information rather than the ability of the authority to take part in arbitrations or anything else. It's the getting of the information that gives rise to the exemption, as I read it. Is that fair?
Yes, I think it probably is fair, but that of course has an impact in terms of its ability to conduct arbitrations in future. If the practice of the public authority is that in relation to its commercial disputes it prefers to arbitrate matters, then the argument is, which is effectively common ground now by reason of what happened in the Court of Appeal since the first instance judgment, the argument is that the, as it were, routine disclosure of such information is liable to impair the ability of Petroleum to, or some other corporation in a similar position, a public authority corporation, to participate in that process. So I agree, although the specific provision of the Act specifically addresses itself to the ability to obtain similar information in future,
yes,
one has to look at that in the broader context as to why one might want to obtain such information in future.
So you say once you get to the Section 35 balance, you can look more broadly at the effect it would have on public authorities in Trinidad to take part in arbitrations, not just because of lack of witness information, but because of the response of the arbitration institutions to those bodies participating in what would otherwise be confidential proceeding.
Yes.
Yes, I see.
And negotiating contracts, if you go further back in time. It may be difficult for Petroleum then to negotiate arbitration.
Oh, well, my lady, quite. I mean, if it were known that state-owned bodies in Trinidad and Tobago might say our disputes are subject to London Court of International Arbitration resolution, but in practice, whatever information they got and put into evidence in such arbitrations would be likely to become public news in due course. That might dissuade people from entering into contracts with them. I hadn't thought of it that way, but my lady, I think respectfully adopt that as a further reason for suggesting that the concession was rightly made. But I accept that. Well, that wasn't. If your lordship's about to say, was that articulated in the courts below? No.
Or in the reasons for refusing.
Or in the reason. No. I mean, I'll come in a bit to the reasons for refusal. As your lordship's seen, they're quite short.
Yeah.
But it might be said to be implicit in that. But I agree. It doesn't certainly put it in that way.
You did say that people would be deterred if it was thought that there would be routine disclosure. But is it right to talk about routine disclosure? Because you'd only get disclosure if the Section 35 balance falls in favour of disclosure. And is that so very different from what was going to happen in this case? Because we've seen Mr. Nelson's second opinion, which was all actually about giving disclosure of the witness statements in the High Court proceedings. So no witness, I would think, could think that they're completely guaranteed confidentiality in whatever they say just because their witness statement is going to be used in an arbitration.
Well, my lord, your lordship's with respect right to pick me up on the word routine. I think that's overstating it. But the point is that for the moment we're focusing on Section 32 and the prima facie exempt nature of the material. And it would be detrimental to the public interest if there was not at least a prima facie position that information which is given in these circumstances in the course of arbitration is kept confidential. Of course, one always takes the risk that in arbitrations too, that developments might ensue, which means that it doesn't stay confidential. Court proceedings, depending on the jurisdiction one's in and how that jurisdiction deals with confidentiality of arbitral court challenges to arbitrations, for example, might affect confidentiality, or it might come out as it might have come out in this action as a collateral effect of a different piece of litigation where it was a relevant document.
I think Article 30 itself says disclosure might be given.
Yes.
If there's a legal duty.
Yes, but there's at least a strong presumption, I would submit, that when you give information for the purpose of its use in an arbitration, it's going to stay confidential. Of course, you take the risk that there might be developments which result in it being otherwise, but for the present purposes, we're concerned with whether the concession was rightly made, that this was a case where prima facie these were exempt documents, and in my submission that.
And the legal duty override in Article 30, it doesn't mean that the material isn't confidential.
No.
It doesn't mean that its confidentiality in an arbitration is not a weighty consideration. When you're having to do a balancing exercise, that still remains on one side.
Yes. Well, that's
albeit it is recognised that it can be overridden.
Yes.
In terms of the timing, is it an inference that could have been drawn that Mr. Nelson's advice upon disclosure in the High Court proceedings brought by Petrofin was a factor which went into the...
What was Mr. Nelson's advice about, does your Lordship mean, was Mr. Nelson's advice about disclosure a factor that went into the withdrawal decision?
And is that...
that certainly isn't how Mr. Nelson couches his advice. He puts it in terms of the merits of the case.
Yes, indeed, but he's not looking at the wider anti-competitive effect on Petrofin disclosing, if there is such an effect. That would
I'll come on. One of the difficulties about this, I'll come on to this perhaps after the short adjournment in the course of my submissions, is that emphasis is repeatedly placed by the appellant on a general suggestion that there's obviously in this case a public interest in disclosing these witness statements. My submission will be that notwithstanding what the courts have said about the burden of proof, or at least the burden on the argument about whether something should be disclosed or not, and I don't intend to ask the board to reverse what has been said in the courts below, but notwithstanding that, it's still necessary for someone who comes along and says, I want this particular document to be disclosed under the Freedom of Information Act, at least to articulate clearly a basis upon which it is to be said, well, the public interest requires it. And what's conspicuous by its absence in my submission from the appellant's case here is any clear articulation of that. It is simply said, well, as a matter of common sense, you can see why it should be disclosed. And to be fair to my learned friend, he elaborated on that in his oral submissions. But
doesn't he go a bit further than that? I mean, isn't he saying this is all rather extraordinary? There was two pretty confident opinions from senior counsel that the case should be brought against Mr. Jones. It was. In September, there was a change of government. In October, Mr. Jones was appointed to the Standing Committee. Within days, there was a whisper in the papers that the case against him might be dropped. Within 10 days of that, Mr. Nelson is writing a very short opinion, and he's, after all, dealing with withdrawal of a $97 million claim, Mr. Rowe, saying that he thinks there's a reasonable likelihood of failure. In all those, and then it's withdrawn and discontinued, and all the costs have to be paid. Isn't that the basis for saying we must please see the basis upon which Mr. Nelson cast his pessimism, which led to discontinuance?
Well, my lord, it depends upon what one is concerned with. The way it's put by the appellant in his affidavit is, well, it's necessary to allay suspicions But to put it bluntly, as we do put it bluntly in our case, bluntly the suspicion is that there's been some sort of political interference in all of this, such that for purely political reasons, the new government has decided, irrespective of the merits of the case, that it ought to be dropped. That's the blunt suggestion. But that suggestion in our submission is one which cannot be taken any further, as far as one can see. There's no reason to think it would be taken any further by disclosure of the witness statements. One could see that if the government was saying we refuse to give you the advice, if Petrotrin was saying we refuse to give you the advice, just take it from us that there was advice that we should withdraw, then one might say, well, surely the Act requires in those circumstances that the advice be disclosed. But that's not the position here. The position is that the advice has been disclosed. I agree it's a short advice, and one looking at it wonders whether one might oneself have written a bit of a longer advice, but it's not been suggested that there's any impropriety on Mr. Nelson's part, and if that suggestion was going to be made, then it would have had to be made pretty fairly.
You see, if this was just one UNC activist saying, it's all very unsatisfactory, that would have to be factored in. But it's a good deal more than that. I mean, could we, just before the short adjournment, possibly go to 573 in Volume 2 of the record?
Yes.
Is this a letter which Mr. Debydeen wrote to the new Attorney General on the 2nd February 2016? Mr. Rowe?
Yes.
Have you got 573 about just under halfway down? Have you got a sentence beginning, I will not allow myself?
Not yet, my lord, but let me go to it.
Bit further down from halfway.
It's copied rather badly, but I've just got it. Yes, I will not allow...
I will not allow myself to be used as the scapegoat in the event there exists a political intention to scuttle or sabotage these matters so they don't proceed to trial. Now, correct me if I'm wrong. Is Mr. Debydeen an attorney?
I believe he is.
Was he the attorney, the instructing attorney, who represented Petrotrin when bringing the case?
Again, I believe so, my lord. I will check, but I believe you're right.
I think had there been further time, Mr. Clayton would have said to us was, it's not just my client, a UNC activist. This is a lawyer raising real concerns about the way in which this has been handled. So would you like, over the short adjournment, to consider that broader alleged concern?
Yes, I will know.
And if that's a convenient moment to you, it's a convenient moment to us.
Right.